Hello, everybody. I'm Randy Helder. I am the Assistant Director of Market Regulation at the NAIC. And this is the PBM Exam Standards session. Earlier this year, the PBM, what used to be the B working group, got transferred over to the D working group to start working on enforcement. And today's session is going to be talking about a lot of the work that they're doing on that working group, but I'm not going to say anything more because they can certainly describe it a lot better than I can. We've got 4 speakers today. We've got online the chair of the PBM D working group. That's Joy Lynn Fix from the West Virginia Department of Insurance, and she is the health director there. To my immediate left is Ashley Scott, who is the Deputy Commissioner of External Affairs in Oklahoma. And to her immediate left is Susan Jeanette, the Director of Consumer Protection and Enforcement at the Delaware Department of Insurance. And then all the way to the extreme left is Jordan Esbrook, who is the General Counsel for the Iowa Insurance Division. So I won't stand in their way anymore. I think they can do a lot better than I can at talking about PBMs. Although, I guess I do have one slide I have to do. The very next slide is the objective slide. Our objectives today is to learn about PBMD working groups standardization efforts, and that's in regards to exams and licensing and registration. And then also take a bit look at examine state-level regulatory trends, and I think we'll be talking about some of the lawsuits that have been occurring throughout the states as well. So with that, I'll turn it over to the stars of the show. Joy Lynn, I think you're starting, Joy.
I am. I'm here. Good morning, everyone, and welcome to the Pharmacy Benefit Exam Standards session. My name is Joy Lynn Fix, and I'm the Life and Health Director here in West Virginia, and I'm honored to be the PBM Working Group Chair of the D Committee, as well as the Prescription Drug Working Group Chair of the B Committee. Today, I am joined by the absolute 2 best Vice Chairs, Susan Jeanette and Ashley Scott, and we want to share with you a little bit of what's happening in the world of PBM management and regulation. While I am sad that I can't be there with you in person today, I do want to point out that my Associate General Counsel for Life and Health, Michael Malone, who his very existence is consumed with PBMs, is in the room with you today and is happy to answer any questions on what we're doing in West Virginia, either after the session today or when you see him throughout the rest of the week. But please be kind to him. He's stuck dealing with me every day. And if those of you who know me well understand what I'm saying with that. We want to start, if you can go, we're going to start with this slide. We want to start by reviewing the charges for this year, especially as it seems that one of them seems to have been missed in the greater realm. So we are responsible for creating and establishing promoting uniform examination and data collection standards for PBMs. We are also to develop exam standards for the Market Regulation Handbook. And here's the one that I want to specifically point out, as there seems to be some questions. In our charges all along this year, we are to develop licensing and registration standards for PBMs. We're also going to address trends, as well as to be the forum to share best practices and exam findings. If you will go to the next slide, and one more. So I want to give you an update with where we are, because there's a lot more important things to share towards the end. I don't want to take up too much time, but the sections for the exam standard chapter are drafted and they have been put into a singular document. We are waiting for one more piece to come in around claims collection, and then the entire document will be sent out to the drafting committee for review before sending it out to the larger working group. We'll then put it out for public comment. After any edits are made from the comment period, we will pass the entire chapter along to the Market Conduct Examinations Guideline Working Group for final approval before it's put into play. They have asked for some subject matter experts to come along with it as it goes, which we will happily do and try to get this all the way over the finish line. Now I want to pass it along to Susan Jeanette to talk to you about licensing.
Thank you, Joylyn. As Joylyn mentioned, one of the subgroups that is charged with doing the registration and licensing requirements for the PBMs. As these entities have been around since the late 60s, they were not really a concern for regulatory agencies, as early PBMs focused primarily on processing claims and developing formularies. As the PBMs started changing and expanding their roles in the pharmacy industry and the insurance world, states began enacting laws in the 20s requiring PBMs to either be licensed or obtain registrations. First, the states had to determine who would regulate them, whether it be the Department of Insurance, public health agencies, or attorney generals. Once the states were able to make these determinations, the agencies and their legislators got busy drafting laws that were necessary at the time. Often the requirements were specific to transparency, network participation, and financial reporting. Another part of the process was to determine whether they should be licensed like an insurer or registered like many states do for a TPA or a third-party administrator. While it can be agreed upon that PBMs do not need to have financial solvency like an insurer does, since they are generally issuing claim payments in a manner similar to a capitative agreement, they do need to have strong structure in place for the organizations and management, as well as establishing policies and procedures, which would be similar to the requirements for TPAs. The difference between the roles of the TPA and the PBM are not often as clear as they are for an insurer or PBM. But if we need to loosely narrow it down to differing parts, we can say that generally insurers will contract with the PBM to use their established pharmacy networks and to have negotiated discounts with pharmaceutical manufacturers, whereas an insurer will often contract with the TPA to collect premiums and perform similar or sometimes different claim processing duties. Because each state has different PBM laws and regulations, the differentiation between a PBM and a TPA are often blurred. Furthermore, we have found that smaller PBMs will often contract with larger PBMs to perform many of these functions. This has caused further problems in determining if the larger PBM's roles is now to be considered a TPA, which would require dual licensure or registration, which we've seen many states now require that. PBMs will manage prescription drugs for millions of Americans across various types of health plans, including commercial, self-insured, Medicare Part D, state government, and Medicaid plans. Without a degree of uniformity in licensing requirements, it can be difficult for the states to effectively regulate PBMs within their borders and to protect their residents, both consumers and pharmacies, from potential harmful practices. Therefore, it's become prudent for the states and the NAIC to work together with interested stakeholders to establish model laws to better unify the licensure or certification requirements and to ensure consistent oversight and consumer protections. On a side note, we are working with the SBS team to develop a module specifically for pharmacist complaints against PBMs and for PBM audits and appeals. If any of the regulators in here would love to be part of this design team, send me an email with your contact information. We've got a good starting point and they anticipate having a model program already designed by the end of the year. Next, we have Ashley, who'll be discussing the different lawsuits. Ashley?
Thank you, Susan. As everybody knows, this is an issue that is very much still in flux. The ERISA preemption challenges to state PBM laws are continuing, some successfully and some not so successfully. The state laws being challenged are varied in scope and focus, and there's a lot of activity underway at the NAIC looking at state PBM laws. As we've heard this morning, there are the groups under the B&D committees that are hard at work. We also have PBM laws that have been a focus at attorneys' roundtables, and the NAIC legal team is tracking a lot of our litigation in the states. In addition, we have the ERISA working group that has convened to discuss guidance after Rutledge and some of the other decisions that have come down. To begin, we will discuss a few states and their legal environment. We're going to start with Jordan Esbrook from Iowa.
Good morning. I'm going to share with you all a little bit about Iowa's experience in the 2025 legislative session with PBM regulation. This is the title of the lawsuit that was brought against our state statute. So that's how I titled my part of the presentation. Iowa passed Senate File 383 in the 2025 legislative session. It was an ambitious bill with many provisions. I've listed a few of the main ones here. Notably, it required PBMs to pay what the bill calls non-chain pharmacies at the National Acquisition Cost, NADAC, and to pay a dispensing fee to those pharmacies. So it had some very direct impacts on PBMs and how they were paying pharmacies in the state of Iowa. The law was immediately challenged by the plaintiffs that I've listed here, the Iowa Association of Business and Industry, which has 600 members in Iowa, and then some specific plans joined the lawsuit as well. The Iowa Bankers Benefit Plan, which is a MIWA, the Iowa Laborers District Health Council and Welfare Fund, orthopedic surgeon group, and a company called the Iowa Spring Manufacturing and Sales Company. As Ashley mentioned, this was brought as an ERISA preemption challenge against 15 provisions of the law. But interestingly, the plaintiffs also brought a First Amendment challenge and argued that the requirements of the law that PBMs and plans can't refer patients to specific pharmacies or promote specific pharmacies, and that they must give notice to the plan members of every pharmacy in the network were compelled speech that would not be permitted by the First Amendment. Governor Reynolds signed the law in Iowa on June 11th, and the plaintiffs, as I said, immediately challenged it and asked for a temporary restraining order to be put in place before the law went into effect on July 1st. The court granted that request on June 30th, which meant the court thought there was a likelihood that the plaintiffs would be able to succeed on some of their claims. Then the case moved on to the next step, which was asking for a preliminary injunction that would remain in place throughout the pendency of the entire lawsuit. And the court granted that as well. So the preliminary injunction prevents the insurance division from enforcing certain provisions of the law against the plaintiffs in the case only. The United States Supreme Court recently in June issued a decision called Trump versus CASA, which limited the power of federal district courts to issue injunctions that are broad and go beyond the scope of the plaintiffs in that particular matter. So the district court was careful to limit it to only the particular plaintiffs in the matter, so the division can enforce the law against everyone who's not part of the lawsuit. And it didn't enjoin every provision of that. So there's a little bit of juggling the different provisions, who they apply to, who they don't apply to at this point. The Iowa Attorney General's Office, which represents the division, appealed the preliminary injunction to the Eighth Circuit in July. So that case is pending. And in the meantime, there's really nothing happening in the district court. So we're all operating under the instructions that the court gave us in the preliminary injunction. So what's enforceable for now? So as I said, the entire law is enforceable against pharmacy benefit managers on behalf of plans that are not plaintiffs in the case. The national acquisition cost must be paid to all retail pharmacies, but the dispensing fee is only for non-plaintiffs. PBMs cannot impact member choice of pharmacy with promotion or penalties or require them to use mail order pharmacy, which is a big requirement. Cannot require more stringent accreditation for participation in the network beyond licensure with the state. All rebates have to be passed through. PBMs can't pay affiliated pharmacies more, so for example, CVS Caremark obviously has affiliated pharmacies that are CVS pharmacies. Quarterly reporting to the Iowa Insurance Division, which we are working on putting into place now, and reasonable ways to appeal. So there's, as you can see, there's quite a few provisions that are still enforceable as part of Senate File 383. So the Iowa Insurance Division is active in working to put all of these new provisions into place.
Thank you, Jordan. Oh, well, where did the last There it is. Okay, sorry about that. I'm going to be visiting about Oklahoma's PCMA v. Mulready case, which I think most of you have probably heard about over the last few years as this has gone all the way up to the Supreme Court. Unfortunately, they did deny to have the hearing. Therefore, these are the following provisions that were decided by the 10th Circuit and were upheld for ERISA plans specifically. The retail-only pharmacy access standards, the cost-sharing discount prohibition, are any willing provider provisions, and a probation-based pharmacy limitation. The court further held in Medicare Part D that they would also be preempted by the Act's any willing provider provision, and we had many provisions that were upheld in the 8th Circuit. Then when it went to the 10th Circuit, they upheld some further things. And so we are looking at, of course, at the other provisions that were still viable within the law and enforcing those through our Attorney General's office and then the licensing portion with the Oklahoma Insurance Department. So these are the provisions that are had been upheld and will not be moving forward. But we are hopeful that as other states are implementing new laws and as we get more clarification from the courts, that we will have a broader respect for how we can move forward with working with PBMs and what that regulation looks like moving forward. Then we're going to go to questions.
Okay.
Got it? Yeah.
So we do have some time for questions. Is there any questions in the audience? We'll have some mic runners that are available. I know PBMs are always a lot of questions for PBMs and understanding PBMs and what's going on and the very important work that this working group is doing. So are there any questions in the audience? Well, while you're thinking, oh, we do have a question.
Hi. I was just curious about like non-preemptive PBMs in markets where the vast majority of PBMs would potentially be preempted either by ERISA or by, some kind of Medicare preemption. And if there's any due process concerns that you've seen in litigation from markets where the ones that are not preempted are only a very small share of the market, under some kind of like disparate impact argument or, even under a rational basis test, just because of how small of a segment that leaves.
Joylyn? Yeah. Joylyn, would you like to respond to that? Were you able to hear the question?
I was, yeah. I wasn't sure if Ashley wanted to. We have not seen issues with that yet. It is something that it's been discussed a few times. But there are no open litigation issues with that at this time. I will say that there was not really a PBM issue per se, regulatory issue, but another issue with a PBM in one state where the state was pursuing litigation with PBMs for something entirely different. And the PBM did wish to have, knowing that they were going to have to pay a fine, wanted to have their fine based off of the share of the market, but not really in the regulatory side. We have not seen that come to play yet.
Any other questions in the audience or any questions on the chat? Yes? Oh, Susan.
One of the things that we have in our Delaware legislation is we built our the first legislation we did, because I think we're now into the third change of it. But the first one we did, we actually have it built in that our laws will apply to ERISA plans for the registration and stuff like that. So we do have some regulatory authority over ERISA plans as it pertains to registration and stuff like that. We initially had pushback from the companies when we did the exams, but it seems to have calmed down some. So I think it depends on how you do the legislation. If you at least build it in there requiring them to be registered and certain requirements with ERISA, that you could get some kind of control over them.
JP.
There was a presentation around alternative funding arrangements at the last NEIC meeting. When you're looking at the exam standards, and obviously when we're looking at companies potentially creating significant barriers to those with serious medical conditions, is that likely going to be something that's included in the exam standards as you start looking at it, knowing that most of the insurers in that space are not in fact doing that, but it's just some of these, weird offshoots? Thank you.
If I can start, and then Ashley and Susan, feel free to jump in and join. It is something that is being looked at, but that is going to be a more state-specific thing. Remember, with PBMs, we don't have the white paper to go off of, or the model to go off of. We do have a white paper. And we have to be very cognizant of the differences in state law. PBM laws vary wildly from state to state. So the funding piece and the pricing is going to default to what that state law is. But that is a discussion that the drafting group kind of talked about, yes.
And that's something, going off what Joy Lynn said about the different states, that's something that we're all trying to look at. Each state has waited for somebody else to start. And once that state did, other states jumped right on and grabbed and built their laws modeling off of the other state. But again, where we were with, some states had their health services, or some had their attorney generals. Now we're seeing everybody's transitioning more over to the DOIs. So now that's where the states are working with the NEIC, and like Joy Lynn said, to build those white papers, to build those model laws. Once your state, if you have legislation in your state, once you start doing exams, you're going to find every session for probably the next 5 years, you're going to be changing your legislation, because the companies are going to come up with different things that you didn't know and you didn't address. So, I mean, it's always good if you know other states that are doing it and stuff like that. Look at what they're doing. Build off their legislation. I mean, I know Delaware, we're in probably the third or fourth rebuild right now because of what we're finding with the exams. Everything is changing. So we're looking at the lawsuits like Ashley and, like they were saying, we're learning from those lawsuits. We're finding what we need to do. So what you have now, don't get excited because you're going to change it next year. But that's what, that's why Joy Lynn's, talking about these committees working with the NEIC to get those model laws done, to get some kind of uniformity, to make it easier for the exam standards and stuff too.
I think too, that bleeds into the licensing. So as everyone's talked about, we're also doing the licensing chapter, and that's going to be beneficial for those states that maybe have a registration and want to move to full licensure, or maybe have nothing and are wanting to move to some degree of that. So we're hopeful that all of the work and collaboration within these working groups will be beneficial to everybody in the room, and look forward to all of your input and feedback as those are released for public comment.
Jordan, quick question for you, since you guys just passed the... Oh, sure, sorry. I apologize. Okay, so I'm going to be even louder than I normally am. Sorry about that. So, Jordan, quick question for you, since you just passed the Senate file. Is it Senate File 383? Okay, so is the dispensing fee based on Medicaid rates? Is that what the Medicaid rate would be in Iowa?
It's statutorily prescribed a certain rate, yeah.
Okay, I didn't know, because I know a lot of states, legislation is based off of that. And then my other question is, and this is more of a policy thing, what type of pushback did you guys get on setting the rate at $10.64? Did people try claiming it was going to jack up the cost of prescriptions astronomically? Did they claim that people on Medicare were going to pay, the senior citizens on a fixed income were going to pay $10.64 extra? Because we ran into that last year when we tried passing our legislation that mandated a dispensing fee, and that was one of the arguments that they made, was it was going to increase the cost of every prescription by over $10. So.
Yeah, I wasn't greatly involved with the efforts at the legislature, but we have heard that said by plans that the the dispensing fee will simply increase the cost for patients when they go, and it'll be passed along. I don't know if I made this clear, but there's a distinction in our law between chain and non-chain pharmacies. There's a definition in the statute. I think it's, you have a certain number of pharmacies in 20 or fewer states, you're not a chain pharmacy. So for example, CVS, Walmart, those are chain pharmacies, and so those do not receive the dispensing fee. Actually, all of that is enjoined now, but the way the law was designed, they don't receive the dispensing fee. And so there was also discussion about, well, are you simply then, encouraging patients to leave smaller pharmacies, which wasn't the intent of the statute, because they could go and get it, more cheaply at a chain pharmacy where the dispensing fee isn't part of the equation. So yeah, it's obviously a discussion that is going to be ongoing, I think, at our next legislative session when the legislature looks at what remains of the statute, what's still caught up in litigation, what, if any, effects the plans and the pharmacies are able to demonstrate have happened after the law, went into effect in July. I think they'll have 6 months worth of data when we go into the legislative session. So yeah, I'm not surprised you heard that. I think that's definitely part of the discussion.
If I can add, from West Virginia, we had those pushbacks as well, and it's simply not proving to be the case. If you pull out spread pricing and require to offer transparent pricing at the same time as you put in your dispensing fee, and then we, in addition, did 100% pass-through rebates, we actually find we go the opposite way. With just switching from spread pricing to doing NADAC plus the dispensing fee, it was an actuarial wash for our health plans. And then when you add in the rebate pass through, the rates are actually lowered, and we're in our 3rd year of data with that. So it's just not proving to be sort of what the sky is falling opponents thought it was going to end up being.
Any other questions in the audience? Do we have any questions on chat? We do? No, we don't. Okay. Well, let me, I've heard a couple things. One in regards to the different regulatory approaches that states have, and then of course we have the lawsuits going on. Can you, and in the middle of all these little changes and stuff going on, you're trying to develop standards. So can you talk a little bit about the challenges of the evolving landscape with the lawsuits and the different, how you're balancing all those different regulatory approaches?
You guys want me to start?
Go ahead, Joylyn.
So we are taking into consideration the lawsuits, but right now there are split in, different circuits are reviewing different things and coming up with different responses. So until we have some kind of, I think we all at this point really wish that the Supreme Court would have taken up already. It would have been either way, it would have given us some finality and some guidance, but they didn't. So we still have to figure out where the common points are and then where we need to leave openings towards the end for state-specific laws. One thing I will say is the definition of PBM is not the same from state to state. So when we're looking at these content, we are looking at, make sure they, for the exam chapter, review the definition of PBM. We're not saying what it should be or what it shouldn't be. We're telling you to review it and make sure that everything that you are doing following goes with that definition of what that PBM is in that state. So I for me, yes, there's uncertainty, but there's also a way to have some uniformity in the uncertainty. Others?
And going off what Joylyn said, that's what we're looking at when we've done exams and stuff. We're finding all these different acronyms and everything else. During the exams, when they're looking at the structure of the PBMs and stuff, they're finding a lot of different parties listed in there that they're using to, get stuff from them, to obtain, either their network or their formularies or whatever. We actually, in Delaware, during the exams that we've been doing, We wait till they've been licensed or registered in our state for a minimum 6 months, and then we'll reach out and ask them, what are you doing? After a year, we'll go in and do the initial exam. We had a list that exceeded 160 names that were found. Out of that 160, we had about a fifth of those ended up saying, oh, yeah, you're right, we actually are a PBM, and became licensed in our state. So you're going to find through this, and again, it's like I said, it's a very blurry line between a PBM and a TPA, because a lot of times they do the similar stuff. It's just to what degree or to what level. We're finding PBMs, the smaller PBMs that are licensed with us, we're finding when they go in to do the exams that they've licensed with the humongous PBMs to do, you know, to do their work, their claims and stuff like that, and their audits and stuff, because they just don't know how to do it, but they have that licensure. But the problem comes in then is what we've seen is those larger PBMs will not release the claim data to the examiners. So we have to tell the little PBM, okay, guess what? We'll give you a pass this time, but next year you're going to be fined. You're contracted with them. So I mean, there's a lot of stumbling blocks that we come across between what the PBMs are doing and what they're not doing or shouldn't be doing. So this is where we're all trying to work together to get those uniform laws. And a lot of it is by the exams that we're doing right now. And that's going to help, like Jolene said, that's going to help get those exam, parameters done too. It's all going to blend together, and it's going to be a mess for at least the first year. But then everything's just going to be flowing beautiful. At least that's what we're hoping.
We actually have a couple of virtual questions that came through. So the first one is, any lessons learned from PBM examinations that have been conducted that would be valuable for other states that are beginning these examinations now?
I will say, to my knowledge, this is not a regulator-only session. So the PBM working group is going to schedule a call. This is about the 5th request I've had. Very soon, regulator only, to discuss those lessons learned. I think to add, just if I would add anything to that, the one brief thing I would say is that PBMs are not used to being regulated, and no offense to them, but they don't know how to be regulated. So anything in your state that you can get with them to take some sort of a class, whether, the one that we knew about, and there could be others that I just don't know about, but we knew about the IRIS MCM class. So we sent out a letter to all of our licensed PBMs suggesting that they take that class to learn what a market conduct exam was and what it meant, and that, they don't want it. We don't really want to be there any more than they want us there, but this is what we all have to do. Any others?
We have a question up front, and then we'll take the second chat question.
I have a question. I'm not in the market conduct area, and I'm assuming since there aren't standardized exam procedures that you're doing these internally with your own market conduct staff. And I guess what I'm wondering is, because this is so nuanced and specific, are there consulting firms out there that do PBM exams, or would you go to a CPA firm? Who would you suggest if you didn't have the resources internally that could assist you in conducting these types of exams?
Joylyn, if you want, I can start with that, because we actually have a PBM team, and we use contracted in Delaware. Our examiners, when they built it. They knew what to look at because they did a lot of work with pharmacists. We have some pharmacists on staff with them also, but they did a lot of work with pharmacists during the initial building of the exam and everything else. We actually met with local pharmacists that are having problems or that are doing good to find out what they're seeing in the situations. So we pretty much took what was there with the regular market conduct and built it around the PBMs. So we did a lot of help with pharmacists. I mean, I'm going to express that. I think we have I think we might be up to 5 now, but we have a lot of companies that we're examining, and our exam team has been invited to attend, like Joylyn was saying, work with your PBMs. They've been invited to attend seminars And they have, and it's been very informative and very learning for all parties involved. But that's the only thing I can say is you're going to have to build it, work with pharmacists, talk to pharmacists and see what they say, what they're seeing and everything else. But don't be surprised, because when you go in to do these exams, they're going to expand. You're going to end up with more questions coming out.
There are some contract firms for smaller states or states that don't have the ability to build out. Susan's team is amazing, by the way. If you can at all copy their setup, you should do that. But there are a couple of contractors that are at different levels of PBM exam work that are out there doing some really great things. Some states are able to have a pharmacist on staff. I am of the belief, and this is not the NAIC belief or anything else. This is my belief. I am of the belief that you cannot do this without a pharmacist. You need somebody that has that knowledge to do an exam. So whether you have to contract it, if you can get one part-time in your department, or if you have, some states have full-time ones, and I'm extremely jealous of them. But there are contractors out there that are doing this work and doing really excellent work with it. And I don't know who asked the question, but if you're interested, contact me offline and I'm happy to tell you who they are.
Do we have one more question in the chat?
Yes, so the next question is, other than the current NAIC PBM projects, what do you think are opportunities for cooperation between states that they can use today?
I mean, I think the ultimate goal would be to get to coordinated multi-state exams where we can. But we're a ways off from being able to do that.
I think in addition to the exams, I think another thing that we're trying to gear towards is the uniformity in licensing requirements. So that way, like now you have a company and you have an insurance company, they're domiciled in one state. It's easy to move and get, the other states then also to get registered there. That's what we want to do. We want to make it easier and uniform to have the PBMs be able to get licensed here and have it across the board that they can move to the other states and not have to go through everything all over again. I mean, that's the one thing that we're looking for, is just to keep as much uniform as possible.
And I think that leads into the consumer complaints and some of those things that Susan mentioned that we're working with SBS on, because it's the whole realm, it's the whole ecosystem, trying to make sure that we are all moving and doing things in the same similar manner.
Any questions from the floor? All right, well, one more question before we wrap up. Just, I think it might be, be good to maybe get a timeline. Maybe you mentioned this at the beginning, Joy Lynn, but what's the timeline for the completion of the exam standards and the licensing and registration, and what's the next step?
Licensing and registration is practically done. I mean, it is out with the committee for comment. We'll review those comments extremely soon. And get it out for public comment. And the exam chapter, the claims portion is supposed to be here by the end of September. We will add it in, get it to the drafting group. Hope to have it out for public comment within a few weeks of that. We really want to push and get all of this done by the end of the year. Now, I do realize realistically with the exam chapter, because there will be more questions, more comments, lots of editing, that we probably will go into the first quarter of next year. And I understand that. But we are going to get this done. We are moving forward. We are going to get this done.
And were you going to involve the market conduct examination guidelines on this as well?
Yeah, when we're done, we've already spoken with them.
Okay, good.
When we are complete with the editing, then it goes to them, and they have requested that a couple of members of our team go as subject matter experts with them, because we are the subject matter experts in the PBM realm. It is a little bit different from typical companies. So yes, we are already speaking with them. They know what's coming, and we will be sending a few folks with them to help answer any questions they may have.
Thanks, Charlene. Your group's doing a great job. If there's any more questions from the floor? Oh, okay. We've got to go at least 5 more minutes to get credit, so we're going to do that. One question I had on here is, how will these new standards, I think you touched upon this, how the new standards will impact smaller PBMs and independent PBMs, both the exam standards and the license, probably primarily the licensing and registration standards.
The licensing for a large versus a small PBM is pretty much going to be the same because it's not something that we're looking at like with a company having solvency requirements. So it's basically it's going to be the same thing. The set fee and everything else is not based on how much work they do. We're not seeing any problems. We have a lot of large and we have a boatload of small ones. What we're finding, again, like I said, is mostly we're finding the smaller ones will subcontract with the larger ones. But for the licensing requirements, it's all the same. It's a uniform price across, and we're having no issues at all.
Good.
Joylyn, do you want to touch on the exam issues with the small versus large?
That's going to default. I think in the exam chapter, it's going to be the same. Across, just like with the licensing. Now, I am aware that there are a couple of states in their state law that have a differentiation of some things between small and large PBMs. I do not in West Virginia. Everyone is treated exactly the same. So, if you are in a state that has that differentiation in your law, of course, that you'll see a little bit of difference between those two. But I do not, and most states are not putting that in their statute. So it's going to be the same for that as well. I will say with the small, we thought that with the smaller ones, we could be in and out with exams faster. That's not necessarily the case. So you just have, it all depends on the PBM and kind of their business model and how they're functioning.
And one of the things that we did, Brother, you mentioned, we're finding with the exams, you will have issues in the very beginning with the small PBM because they'll subcontract with the larger ones, and the larger ones will refuse to give out the information. They'll claim it's proprietary. Thank you. They'll claim it's that, but we have to remind them our records are not foyable. Their investigation records, reports, you need to share it with us. We had one company that we reached out to help the small PBM, and the large PBM said no. So we had to end it with the small PBM saying, next year when we come in with the full exam, you will be fined if you don't have the records. You own the contract, you need to enforce the rules.
Yeah.
So it's just giving that little PBM, giving them the support, building that rapport with them to give them the strength to speak back up. And I think, again, with any exam, it comes down to working with the companies.
I think too on the licensing side, like I know Oklahoma has, depending upon the number of members that the PBM has, then they have a tiered approach on like surety bonds and things like that are required for licensure. And so that was one of the things that we took into account when we were developing the standards that you all will be reviewing and commenting on. And so there are some approaches that have been made to tier some of those capital requirements, bonding requirements, and some of those other things on the licensure side that you'll be seeing and have the ability to comment on.
Any questions? Otherwise, I can ask another question. So you talked a little bit earlier, I think in the lawsuit discussion in regards to the ERISA preemption, what are some of the challenges with kind of coordinating with federal agencies and federal law, and are you finding that to be a challenge, and how are you addressing that?
I think at a higher level, of course, any changes that the federal government's trying to make, we're trying to make sure that we can retain our regulatory authority at the state level on all of these entities. Joylyn may have some other examples of conversations with federal agencies, but I think that's always the pursuit of the NAIC, is to retain that jurisdictional regulatory piece and working with them to make sure that whatever laws, if they were to pass something, that it doesn't hinder what we've already done in the states, because there's many states that are way ahead of where we're at the federal level.
I completely agree with that. You know, the conversations are right now with the federal level is, you know, what we want to do. We are going to do, well, nothing is done yet with PBMs. And we all understand that PBMs are a hot topic, and they eventually there probably will be some federal regulation on them. That's something that, you know, has been very bipartisan in almost all of the states, is the PBM regulation. So is something going to come eventually? Yes, probably. But until it does come, you know, states continue to go on their own. And the longer that they wait federally to do something, then the farther, as Ashley pointed out, states go. And the farther we're along, and we can't go backwards. So all conversations are focused towards that we need to be able to maintain our state regulatory authority and go with where we are, because, you know, we've all put significant time in this, not only the regulators, but the PBMs. They don't, you know, starting from scratch would not be good for them either.
Absolutely. Thanks, Joylyn. Other call for questions? All right. I think we've met our CE time, right? All right.
Randy, if I may, just one more
Absolutely,
thing, if you wouldn't mind if I add. I know that there are some new regulators in the room, and the three of us are happy for you to get involved and join. We are a very open group. I've already gotten an email, so yeah, Vermont, I see you. We're an open group, and we want you to be involved. We want you to ask the questions. If you are unsure of something with PBMs, please call us. Call me. I'm happy to talk to any of you at any time. We will make it happen. I pull my entire PBM team on the phone so we can try to answer all of your questions at once. We've done that with a number of states. I know that Ashley and Susan are absolutely willing to do the same thing, and get involved. We do have this D committee group. We have a B committee group that's looking more broadly at prescription drugs, not just even the PBMs, but looking at things like formularies and specialty drugs and all the things, because right now pharmacy is a huge cost driver of health plans. So please get involved wherever you are in your process. We want you to be involved, and we want to help where we can.
And going again off what we were saying of building the module with SPS, if you don't have time to do it because everybody is stretched thin, if you want to be heard, please send me your appeal forms, any appeal documents that you have or whatever, and we can make sure we put that into the development of the module. So if you have appeal forms for pharmacists or PBMs or anybody, send it to me. We can build it right into the module too. We'll look at everything and put, you know, all the state stuff in there together.
I was going to add, if you think it would be useful to look at the actual text of our statute SF 383 or at any of the briefing or the court's decisions, it's kind of it's very detailed. As you could tell, there's a lot of provisions, and each of them had to be analyzed separately. So feel free to contact me at the Iowa Insurance Division if you'd like to see any of those documents so you can read them for yourself.
If you wouldn't mind, Iowa, we have a Connect page that is regulator only, and Jolie uploads documents to that. We could put it there so that everybody can see it without you having to individually send it out, because it is very helpful.
Yeah, that's a great idea. Thanks, Joylyn. I think anything that I have is public, but I am happy to, you guys can post it wherever you think it would be most useful for the group.
We have a document repository in the Connect page that might be a fast place for everyone to get to it. And with that being said, if you are not, as a regulator, on both of the Connect groups, you get hooked into that, because there's great information there.
All right. Well, thank you all for your great work on the working group and the developing the standards. And